Financial powers of attorney. 6 common mistakes you need to know and avoid. Watch this video to avoid key mistakes and to learn how to make your power of attorney as beneficial as possible. Contrary to popular belief, a financial power of attorney does not need to be complicated or difficult to make, but you got to do it properly. Familiarizing yourself with the most common pitfalls will help you avoid missteps and make the most of your power of attorney. Check out our top frequent mistakes in financial powers of attorney. Welcome back, folks, to another edition of Sweetie Kiwi. How are you doing today? I hope you are doing fantastic. I'm doing terrific. If you are doing as marvelous as I am, grab a cup of coffee or tea or vodka and let's roll. Today I want to talk to you about financial powers of attorney. 6 common mistakes you need to know and avoid. Number 1, appointing your agent as joint owner of your bank account. This is a mistake that a lot of legal experts have seen over the last 20 years. The most common task for agent is writing checks and paying bills from your bank account. To do this, you'll have to add your agent's name to the account. Of course, that's when you might mistakenly add your agent as a joint owner. Remember though, adding a name to the account can mean 2 different things, and this applies to all 50 states and even some provinces in Canada. So it can mean either the person is authorized under your power of attorney to manage the account on your behalf. That's option number 1, on your behalf. Option number 2, it can mean the person is a joint owner with full authority to use the account as his or her own. So you might unknowingly add a family member's name to your account as a joint owner. This happens all the time. Now, if you do this, the account will immediately become that person's property when you die, no matter what your will says. Let me repeat that. If you add a family member's name or anybody else's name for that matter to your account as a joint owner, the account will immediately become the person's property when you die, no matter what your will says. That will mean your property, for instance, will be vulnerable to your agent's creditors and liabilities. Your agent may get property you never wanted to give him or her. This could mean your agent gets more of your estate than you intended, and others might get less. Even if your agent understands the mistake and voluntarily distributes the account to the beneficiaries you intended, this could complicate the administration of your estate. To avoid this mistake, it's very easy, folks. So after you complete your financial power of attorney, take it to the bank. Talk to your banker. You want to make it clear that you do not want to add your agent as a joint owner, but under your power of attorney. And to make things even better, you want the bank to confirm in writing that they have understood your instructions. Again, make it clear you do not want to add your agent as a joint owner, but you want to add them under your power of attorney so that they can manage the account on your behalf. They're not joint owners. They don't own the account. They just managing the money, the property, the income, whatever is in your bank account on your behalf. Very critical, folks. Let's now talk about the second most common mistake you need to know and avoid when it comes to financial powers of attorney. Not understanding your agent's duties. A lot of folks they're not very clear about the duties of an agent. Your power of attorney does not just give your agent legal authority. It also imposes legal duties. That's where you have the legal financial term fiduciary. There are duties. There is an expectation of loyalty. For example, your agent has a duty to act according to your wishes. Your power of attorney, in this case, should lay out a full list of your agent's duty. Be as clear and thorough as possible. Be as comprehensive as possible. We don't want to be lazy here, folks. This is an important matter. We're talking about estate planning. We're talking about you transferring parts of your legal right to someone else. So you got to be as complete and thorough as possible. So you want to lay out a full list of duties you would want the agents to have. Your state probably has a statute that defines these duties by default. Your agent consequently must follow those defaults unless your document specifies different duties. Varying your agent's duty away from the statutory requirements can be useful in some situations. Remember, states have the template, the default template. Authorities want to make sure that things have their goals is to have a seamless process. If your goals are different, if your priorities are different, if your preferences are different, you want to customize things, right? So you want to customize the list of duties that you are assigning to your agent. For example, the default template duties in the default template might be to keep detailed records sometimes and not all the time. So you have an agent who, for instance, in New York might be required to keep detailed records, whereas when you go to Arizona, for instance, this sort of record keeping is not always needed. This duty can become a huge burden because it forces the agent to keep track of every receipt and document. Many agents don't have the time to be so meticulous. If you trust your agent, removing this duty could make the job much easier. To get a better understanding of your agent's legal duty and which ones you might want to change, you want to reach out to your state, estate planning department, or estate planning service, if you will, or reach out to an attorney. Whether or not you choose to change your agent's default duties, you should know your state's default rules, and so should your agent. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of City Kiwi. I hope you are doing fantastic here. We're still having a conversation around financial powers of attorney, 6 common mistakes you need to know and avoid. I've already given you 2. I'm going to move on to number 3. So the first 2 were not appointing your agent as joint owner of your bank account. That's a big no-no. Not understanding your agent's duties. Another big no-no. Let's move on to number 3. Not ceding authority over all types of property. When it comes to setting up a financial power of attorney, people sometimes are tempted to give authority over just the types of property they currently own. This could be a big mistake because if that were to happen to you, you don't know what you'll own in the future. You're thinking about your situations right now at the moment where you're setting up the power of attorney, but things change. People become richer, people become wealthier, things change, they get married, they have children. So a whole set of circumstances can be part of the equation at a future date. So you want to plan ahead. When you make a financial power of attorney, you can give your agent a lot of authority or very little. Basic forms often list various types of property, requiring you to check or initial each one to give your agent that authority. Let's go through, when you have a basic template, let's go through the list of property items that you might want to see. You have things like real property. Here I'm talking about houses, apartments, condos, land. You also have tangible personal property, so valuables, jewelry, that kind of stuff. You have digital property. You have stocks and bonds, commodities and options, banks and other financial institutions, operation of entity or business, insurance and annuities, estates, trusts and other beneficial interest, claims and litigation, personal and family maintenance, benefits from governmental programs or civil or military service, retirement plans, and taxes. Of course, taxes are not a type of property, but the goal here is that if you are ceding authority of certain items to your agent, fiscal responsibility could also be a part of it. In other words, you might receive refunds. So if you receive refunds, you want to make sure that your agent knows about it and knows how to direct the funds. If you look at the list, you will see some types of property you don't have at the moment. For example, you might not own commodities and options. You might be tempted to skip that category, thinking it doesn't apply to you. But this is not a great strategy. Why? There are at least two problems you can have when you skip that category, and among others, just want to specify that there might be two problems with that. You might not know what is and is not included in each category. What's considered, for example, digital property? What does other beneficial interest mean? A category could apply to you without you realizing it. That's the first problem. The second problem is you don't know the future. As I said earlier, things happen, people change, live events change, people get better, people get married, they get wealthier. You might inherit some stocks from your grandfather. You might decide to start a business, a side business 3 years from now, 5 years from now, 10 years from now. Your agent needs the power to deal with whatever comes up. The best approach, according to multiple legal experts, is to grant general authority over all types of property, even property you don't currently own. It is advisable for your agent to have the authority, even if they never use it, than not have it at all. Let me give you a few exceptions, because here we're talking about generalities here, but it's important to have, whenever you broaden the spectrum of legal scenarios, it's always advisable to have exceptions. Don't grant any powers to your agent that make you uncomfortable. There is a legal term called duress. Duress is undue influence. So you don't want to give anything under duress. You don't want to grant any powers that make you uncomfortable. Specifically, if you have, say, concerns about your agent's ability to manage certain types of property, or if you think that your agent might take advantage of you financially, you want to consider other options. You can limit the power you grant, for instance. You can set up a trust instead. You can name through that trust an additional person to advise or supervise your agent. Or even better, for some people, you can rely on a court supervised guardianship. So the court will appoint a guardian to administer your finances. Now, it is always essential to reach out to an attorney. This show is not about giving you any kind of financial advice or legal advice. We are giving you an overview of the equation when it comes to the financial powers of attorney. Your situation might be different. Everybody has a different situation. So it's always better to consider entrusting your legal affairs into the services of a lawyer. He or she will be apt when it comes to looking into your financial matters and helping you devise what really can help you move on with your life from a legal standpoint. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. We're also having a conversation around financial powers of attorney, 6 common mistakes you need to know and avoid. And I've given you 3 already. And if you love the clarity and quality of the content so far, please consider subscribing to our channel and turn on the notification bell so you can receive notification in real time whenever we drop a new show. And we kind of release this sort of shows every single day, rain or shine. Comment below, like this content, and share. Mistake number 4, not working with your banks and other financial institutions in advance. Banks and other financial institutions, here I'm talking about wealth management firms, asset management firms, insurance companies. They play a key role when it comes to estate planning. It is natural to assume that, like a power of attorney for healthcare, your financial power of attorney will be readily accepted by any financial institution or government agency. Things don't happen always that way. Working, therefore, with your financial institutions can prevent delay in the future. So what you're doing is you're planning things now to save time in the future. Financial institutions are known to reject financial powers of attorney all the time. Some institutions want to see specific things in a power of attorney document, such as notarization, even though a financial power of attorney in many states does not have to be notarized to be valid. Other banks and financial institutions want you to use their own form or attach a lengthy form and certification. We've seen some insurance companies, for example, where the process of receiving, reviewing, and approving your power of attorney can take weeks or even months, especially when you have some kind of corporate reorganization. So a company has been sold or bought or has merged with another. Government entities are not much better, especially big agencies. I'm talking Social Security, Department of Defense, the VA. They have their own procedures you need to follow. So it's always best to anticipate these difficulties before time is short. My point here is that you want to start working with those institutions in advance. Don't wait until the last minute. Don't just sit in your corner and just get your own stuff done and have your lawyer prepare everything and not communicating with those sort of big stakeholders. And then when things happen, you just reach out to them. No, include them in the process from the get-go. You want to talk to your banker and make sure that the form that you're using, they're comfortable with that, they understand that, and they will get it approved. What you want to do is you want to get buy-in. So either you use their own form, their own templates, or use one that they have reviewed and approved in advance, and always get things in writing. So if a bank or insurance company or wealth management firm has agreed to the template you're going to use, make sure they say so in writing. Same thing with Social Security. You want the administration, the agency rather, to sign something stating that they have reviewed your financial power of attorney and they're comfortable with that. Mistake number 5, not using your power of attorney. Your power of attorney here is probably effective as soon as you sign it. As soon as you put the signature underneath in the last page, in the last form, on the last page of the form, it becomes effective. That means your agent can be added to your bank account and conduct transactions on your behalf immediately. In this case, it's always a great idea to give a copy of your power of attorney to your bank at the very least. I would say also to your insurance company. You might want to do the same thing with the Social Security Administration. Consider sending it to your life insurance, investments, and retirement companies as well. If you happen to have a financial advisor, don't wait until things happen, catastrophe strikes. You want to give him or her a copy too, ASAP. That way your agent is ready to step in at any moment if things were to happen. You don't manage your own affairs. You can put your agent to work right now. For example, you might need someone to sign papers at a real estate closing while you're out of town. You can have your agent sign the papers for you. In fact, a lot of folks use limited powers of attorney just for this set of situations. So you're not giving your agent full authority, you're giving them limited, restricted authority. So that's a common mistake because you have the power of attorney, you have the document, you have everything set, but you're not using it. So you're wasting time, you're wasting money. For instance, if you have to travel somewhere, or let's say you are at a hospital, God forbid something happens to you, you're not doing well, you're still doing things yourself as opposed to relying on your agent. That's kind of that's unwise. Think about it this way. It's like you hire a new employee, but you are continuing to do the work for which you have hired someone, and you're paying the person because remember, agents are paid. In some cases, if you choose an organization such as a bank to be your agent, they are going to charge you fees every month or every quarter or every year. So they are paid. So you're paying them for doing nothing. So you need to start using them as soon as you have signed the paperwork. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of City Kiwi. We are still having a conversation around financial powers of attorney, 6 common mistakes you need to know and avoid. Let me sort of wrap up today's conversation by giving you the number 6, the sixth mistake. Common mistake that a lot of folks make when it comes to financial powers of attorney: not knowing when to give extra authority to your agent. So we've had a conversation about limiting your agent's duties and powers, but there are moments when you need to give extra authority to your agent. If you look at a simple financial power of attorney form, you might not realize that there are significant powers it does not include. You got to know about this possibility so that you can decide whether to grant your agent extra authority. Remember, when it comes to agent, we have the fiduciary element here. It's all based on trust. It's all based on loyalty. It's all based on being comfortable with the agent you've chosen. Basic powers of attorney usually do not include the authority to make gifts from your property, create or amend trusts, change beneficiary designations on life insurance and retirement accounts, delegate the agent's power to another person. Yes, agents are also human beings. Something might happen to the agent. If you have chosen a human being as an agent, and that agent becomes incapacitated, there has to be a backup plan. There has to be a successor agent. So you got to think about that. So many power of attorney forms do not include these powers because they are dangerous if given to the wrong person. If not exercised with care and good judgment, these powers can deplete your property and ruin your estate plan. However, and this is a big however, if you happen to trust your agent without reservation and you want your agent to have as many options for taking care of you as possible, these powers can be useful. The thing here is that, and again, I want to stress this, because these extra powers can be dangerous in the wrong hands, you want to talk to an attorney before including them in your power of attorney document. At the very least, you want to have a second or a third opinion before granting this sort of extra authority. One thing you can also do is to have some kind of scheme or kind of system where you're having someone checking what the agent is doing. This is what I was talking earlier about, having a backup plan, having a successor agent, you can even have 2 agents. It's all about the complexity or the complexity of your financial affairs or the size of your estate. Obviously, if you just own a few stocks and bonds here and you have a very small, I would say a small estate, you don't need such a convoluted scheme. But if you have a large one, you want to think about those kind of stuff. So not knowing when to give extra authority to your agent is mistake number 6 when it comes to financial powers of attorney. Let's quickly recap today's conversation here. Today I was talking to you about financial powers of attorney, 6 common mistakes you need to know and avoid. Here are the 6 mistakes. Appointing your agent as joint owner of your bank account. Not understanding your agent's duties. Not ceding authority over all types of property. Not working with your banks and other financial institutions in advance. Not using your power of attorney at all after it has been set up. Not knowing when to give extra authority to your agent. Obviously, folks, we're not providing legal advice in this show. This is a quintessential disclaimer here. Our job is to conduct research, package the research in a very easily understandable format, and share with you. If you have specific needs, or your family has specific needs when it comes to finances or healthcare considerations, you want to reach out to an attorney. You want to reach out to someone who is well versed in the subtleties of estate planning in your state, so that he or she can help you, can understand your situation, and craft a document, a financial power of attorney document that encompasses all your needs, encompasses all your priorities, encompasses all your wants. And the attorney might even help you find the right agent if he or she is not your agent in the first place. One thing that's also important is that pay attention, please, to other stakeholders, specifically banks and other financial institutions, as well as the government agencies, such as the Social Security Administration. You want to pay attention to their needs also, and making sure that whatever you do is in alignment with what they want from you. For instance, the financial power of attorney form must match, or at least must match what they have, or at least get approved by them beforehand. I will see you another time, but until then, remember, stay marvelous.